Assembly, which has adopted a resolution calling for the immediate withdrawal of Russian forces from Ukraine. The International Criminal Court, which, as you've heard, has received referrals of the situation from 39 states. The UN Human Rights Council, which has established an international commission of inquiry for Ukraine. The European Court of Human Rights, which has issued an interim order requiring that Russia refrain from military attacks against civilians and civilian objects. Regional organizations and nation states, which are imposing a vast web of rigorous sanctions on Putin and his accomplices based on their illegal activities. And national prosecutors who have already begun to launch investigations into whether Russia's leaders have committed the crime of aggression. Within its own legal mandate, each of these bodies must do its own job. So if you speak clearly and decisively now, you will not act alone. Other parts of the international legal system will act in concert with you, focusing on other aspects of Russia's aggression. But amid this broad network of legal activity, your order is the essential spark that will inspire other competent international organs and agencies to take the further steps necessary to protect peace, security, accountability, and human rights in this rapidly deepening crisis. For that reason, we ask you clearly to declare, prima facie, that there is a dispute between Ukraine and the Russian Federation relating to the interpretation, application, and fulfillment of the Genocide Convention. In particular, Article 1, which addresses obligations of states to prevent and punish genocide, and Article 4, which addresses punishment of those who commit genocide. Ukraine further disputes that Russia has any lawful basis whatever to take its military action in and against Ukraine for the claimed purpose of preventing and punishing genocide. Whether or not Russia chooses to appear, declaring the existence of a prima facie dispute between these two countries is warranted in this case. Ukraine further asks that you find no plausible evidence that Ukraine has committed the non-existent genocide for which it has been accused. In particular, first, that no acts of genocide as defined by the convention have been committed in the Luhansk and Donetsk oblasts of Ukraine. Second, that it is plausible that the special military operation declared and being currently carried out by the Russian Federation is based on a false and fabricated claim of genocide that has no basis in the convention. Not only is there no serious risk that genocide will be committed by Ukraine, there is no risk whatsoever. Third, that lawfully the Russian Federation cannot take any action under the Genocide Convention, military or otherwise, in or against Ukraine for punishing or preventing an implausible alleged genocide based on its false claims of genocide in Luhansk and Donetsk. In so indicating, the court should make clear that under the convention, the targeting of Ukrainian civilians and civilian infrastructure can never, under any circumstance, be a lawful exercise of a country's obligation to prevent genocide. And even if Russia scrupulously complied with the law of armed conflict, which of course it is most assuredly not doing, acts of aggression against Ukraine's defenders can never be a lawful exercise of a country's obligation to prevent and punish genocide. And fourth, that the Russian Federation may not invoke a false claim of genocide committed by Ukraine as a legal basis to justify the actions of the Russian Federation in recognizing the independence of the so-called DPR and LPR. Now, within this broader factual context, other international bodies, including the International Criminal Court and the European Court of Human Rights, are exploring the scope of accountability for particular actions by Russia, its leaders, and its proxies. But given this court's special, unique status in international law, the whole world is looking to you for guidance and leadership. Once you have fulfilled your role, these other bodies can fulfill theirs. A recognition that Russia has no colorable legal basis in the Genocide Convention for its brutal actions in Ukraine would provide ample legal grounds for the first two specific provisional measures we request. These measures are clearly linked to the rights asserted by Ukraine regarding Russia's bad faith invocation of the Convention and Russia's abuse of its rights under Articles 1 and 4 of the ordered similar provisional measures before, against an ongoing military operation being committed by a permanent member of the UN Security Council. As you well recall, in Nicaragua versus United States, this court declared that the United States of America should immediately cease and refrain from any action restricting, blocking, or endangering access to or from Nicaraguan ports, and in particular the laying of mines in the port of Corinto. That order added, as yours could as well, that the right to sovereignty and to political independence possessed by Ukraine here, like any other state of the region or of the world, should be fully respected and should not in any way be jeopardized by any military and paramilitary activities which are prohibited by principles of international law. In particular, the principle that states should refrain in their international relations from the threat or use of force against the territorial integrity or the political independence of any state, and the principle concerning the duty not to intervene in matters within the domestic jurisdiction of a state, principles embodied in the UN Charter. In October 2008, this court ordered both Russia and Georgia, as parties to the armed conflict in South Ossetia, to do all in their power to ensure that public authorities and public institutions under their control or influence not engage in acts of racial discrimination. And the court ordered similar relief when indicating provisional measures in Congo versus Uganda, declaring that both parties must forthwith take all measures necessary to comply with all of their obligations under international law, in particular those under the UN Charter. Second, Ukraine requests that the Russian Federation shall immediately ensure that any military or irregular armed units which may be directed or supported by it, as well as any organizations and persons which may be subject to its control, direction, or influence, take no steps in furtherance of the military operation which have as their stated purpose and objective preventing and punishing Ukraine for committing genocide. Recently, in the Gambia v. Myanmar, the court's provisional measures order similarly extended not just to members of the respondent states' military, but also to the same group of other actors, any irregular armed units which may be directed or supported by it, and any organizations and persons which may be subject to its control, direction, or influence. In issuing this second provisional measure, the court should take account that no purported obligation to prevent genocide or any other manufactured legal justification could justify either the deliberate targeting of Ukraine's democratically elected political leaders or Russia's failure to take all necessary precautions in attack resulting in de facto targeting of those leaders. And there should also be no doubt that no act in this war is lawful or authorized by the Genocide Convention, so that the only way to preserve the status quo and protect Ukraine's rights is to order a complete suspension of Russia's military operations. Again, this is not unprecedented. The court has regularly given direction to parties regarding the movements of armed forces and personnel in ongoing military operations. In Cambodia versus Thailand, the Priya Vihir case, in 2011, the court issued an order on provisional measures nearly 50 years after the operative judgment, directing that both parties shall immediately withdraw their military personnel currently present in the provisional demilitarized zone and refrain from any military presence within that zone and from any armed activity directed at that zone. Similarly, in Burkina Faso versus Mali, the court ordered both governments to withdraw their armed forces to such positions or behind such lines as may be determined by an agreement between the governments or failing such an agreement by the chamber. In Costa Rica versus Nicaragua, the court likewise ordered each party shall refrain from sending to or maintaining in the disputed territory any personnel, whether civilian, police, or security. Madam President, members of the court, there is a clear link between these first two provisional measures that Ukraine requests and the plausible rights Ukraine seeks to preserve while its application is pending. As you've heard, the risk that Russia will irreparably harm Ukraine and its people in the name of preventing and punishing a non-existent genocide is very real. Unless Russia halts its military operation, Ukraine's plausible claim that Russia is violating and abusing the convention will only be heard when it's too late. As Ms. Cheek explained, the rights that Ukraine asserts are grounded in Russia's bad faith performance of its obligations and its abuse of its duty to preserve and punish genocide under Articles 1 and 4 of the Convention. The first two provisional measures share a direct link to Ukraine's right under Article 1 to good faith performance of the Convention by any state party. Russia's abuse of the Convention is the source of its claimed authority to use force in Ukraine. Thus, provisional measures by your court directed against that lawless use of force would directly target the abuse of rights at issue here. Third, Ukraine requests that this court direct the Russian Federation to prevent any aggravation or extension of the dispute by refraining from any action and providing assurances that no action is taken that may aggravate this dispute or render it more difficult to resolve. This court gave similar direction when indicating provisional measures in Congo, Uganda, directing that both parties must forthwith prevent and refrain from any action, and in particular any armed action, which might prejudice the rights of the other party and aggravate or extend the dispute or make it more difficult to resolve. The court gave a nearly identical directive in its order in Cameroon, Nigeria, again declaring both parties should ensure that no action of any kind, and particularly no action by their armed forces, is taken which might prejudice the party's right in respect of a future judgment or otherwise aggravate or extend the dispute before it. Given the level of atrocities that are multiplying daily and that you heard of from Mr. Gimblett, the court should further order Russia not to aggravate the ongoing dispute by refraining from violations of human rights and humanitarian law in the course of military activities. In the Gambia versus Myanmar, You recall this court gave specific instruction that entities under its judicial supervision shall not commit genocide, conspiracy to commit genocide, complicity in genocide, or attempts to commit genocide. In Congo, Uganda, the court likewise ordered that both parties must forthwith take all measures necessary to ensure full respect within the zone of conflict for fundamental human rights and for applicable provisions of humanitarian law. Less than 3 months ago, in Armenia versus Azerbaijan, the court ordered the parties to protect from violence and bodily harm all persons captured in relation to a conflict who remain in detention and ensure their security and equality before the law. The threat to the Ukrainian people is no less urgent. Fourth and finally, Ukraine requests that the Russian Federation shall provide a report to the court on measures taken to implement the court's order on provisional measures 1 week after such order, and then on a regular basis to be fixed by the court. The gravity and rapidly evolving nature of the situation in Ukraine, which has changed by the hour, call for a clear and ongoing reporting requirement to monitor Russia's compliance with the order you may issue. Regular public reporting, as was ordered in the Gambia versus Myanmar, can allow you more directive rulings in the future if monitoring demonstrates that Russia has refused to comply until the court can render final decision in this case. Like the other measures we request, the fourth measure has the express goal of protecting the integrity of this proceeding before the court and assuring that the court is properly equipped in due course to decide the merits of Ukraine's claim. Whether or not Russia chooses to appear and defend in these proceedings, it would be subject to the court's prima facie jurisdiction under the convention and should be required to account for its compliance with binding orders of the court. To be clear, the preliminary relief we request will not be the final relief requested. On the merits, Ukraine will seek final declarations of illegality, specific assurances, guarantees of non-repetition that the Russian Federation will not take any unlawful measures in and against Ukraine, including the use of force on the basis of its false claim of genocide. In time, Ukraine will seek full reparations for all damages caused by the Russian Federation as a consequence of any action taken on the basis of Russia's false and fabricated claim of genocide. But those requests are for later. For now, we ask not that you give final relief, only that you indicate provisional measures in such a way that leaves that possibility open. Madam President, members of the court, in less than 2 weeks, this case has become much bigger than just Ukraine versus Russia. It has become a test of who will prevail, Russia or the post-war international legal order. The tragedy we are all witnessing in the streets of Kyiv, Kharkiv, Mariupol, Kherson, Volnovakha, and so many other Ukrainian cities is precisely what our modern international legal system was designed to prevent. Just 77 years ago, we, the peoples of the United Nations, determined to save succeeding generations from the scourge of war, to reaffirm faith in fundamental human rights, and to establish conditions under which justice and respect for the obligations arising from international law can be maintained, created the United Nations and this court. But what is the point of having these bodies if they do not act strongly at this moment of transparent aggression and injustice. Madam President, members of the court, President Putin's short game is force. The world's long game is law. For the other institutions to do their job inside and outside the UN system, first, you must do yours. The court's limited role at this juncture is to order the urgent measures of protection that we request that would enable the convention and the broader UN system of which it is a part to work as intended. But if this court does not act decisively against this level of aggression and atrocity based on outrageous abuse of one of the world's most important human rights treaties, rest assured this would not be the last such case. Putin's aggression and atrocity would not end with Ukraine. If this court cannot decisively order Russia to stop its military actions grounded in flagrant abuse of and disrespect for the Genocide Convention, why should any permanent 5 UN member see international law as a meaningful obstacle to whatever it might perceive as necessary military action? Then why wouldn't we be forced to concede that the post-war international legal project has failed? Madam President, members of the court, that cannot be the outcome here. Of course, there are limits to what the principal judicial organ of the United Nations may do. But by issuing decisive provisional measures, you can meaningfully preserve the status quo, follow precedent, while leaving room for complementary action by other international bodies. The provisional measures Ukraine requests are reasonable, achievable, and grounded in the very measures you've granted in the past. You have undeniable legal authority to act. Anything less would fail to vindicate the rule of international law under these most dire of circumstances. For all of these reasons, we ask you immediately to issue the provisional measures order that Ukraine so urgently requests. Madam President, members of the court, the world awaits your actions. I now ask you to give the podium to our co-agent, Ms. Zolotaryova, who will present Ukraine's final submissions. Thank you.
I thank Professor Ko, and I now give the floor to the co-agent of Ukraine, Ms. Oksana Zolotaryova. You have the floor, madam.
Madam President, distinguished members of the court, I am honored to conclude Ukraine's oral pleadings and make Ukraine final submissions regarding its urgent request for the indication of provisional measures. Ukraine has now faced 11 days of Russia's brutal invasion of Ukraine. Many people said we could not withstand Russia's aggression for so long. They underestimated the people of Ukraine. They underestimated our spirit, our unity, our devotion. Ukrainian heroes are bravely defending Ukraine, and we will keep defending Ukraine until the aggressor leaves. Ukraine is being supported by the civilized world. We are grateful to each and every act and effort to support Ukraine, but we need more help. We need more help from our allies. We need more help from every institution in the world. That includes this court. Your power to act is clear. To defend actions, they are indefensible. The Russian Federation fabricated allegations of genocide out of nothing. It used this horrible lie as a pretext for its unlawful assault on Ukraine. In doing so, Russia cynically abused the Genocide Convention. Russia twisted the crime of genocide to justify the crime of aggression. In the name of preventing and punishing the crime of genocide, Russia is committing war crimes and crimes against humanity. Ukraine has come here before you, the World Court, to seek urgent protection for everyone who lives in Ukraine. As Professor Tuvenan explained, there is no doubt a legal dispute under the Genocide Convention. As Mr. Zayan showed, the reports of UN missions and other neutral observers confirm that Russian allegation of genocide is absurd. Marnichik demonstrated Ukraine's right not to be illegally invaded based on a bad faith abuse of the Genocide Convention by Russia. Mr. Gimblet highlighted the extreme urgency of the situation, and Professor Ko explained why the court can and must order the measures Ukraine requests. I could rest the Ukraine's case here, but in this difficult moment, I am compelled to remind the court of the real human stakes of Ukraine's requests. As I am speaking, the Russian Federation continues its relentless assaults on our cities, on our towns, on our villages, on our people. This assault has taken many forms. My hometown of Kharkiv suffers for days from indiscriminate shellings, but heroically resists. Churches are ruined, hospitals are ruined, universities are ruined, civil infrastructure is ruined there. None of this can be considered as legitimate military target. The world is witnessing and documenting how Russia kills civilians in its indiscriminate attacks. We don't know yet the true number of Ukrainians that Russia has murdered in the past 11 days. We can only guess how many more will be murdered in the next 11 days if this senseless aggression does not stop. In these extraordinary circumstances, Ukraine requests that the court order the following provisional measures. A. The Russian Federation shall immediately suspend the military operations commenced on 24th of February 2022 that have as their stated purpose and objective the prevention and punishment of a claimed genocide in Luhansk and Donetsk Oblast of Ukraine. B. The Russian Federation shall immediately ensure that any military or irregular armed units which may be directed or supported by it, as well as any organizations and persons which may be subject to its control, direction, or influence, take no steps in furtherance of the military operation, which have as their stated purpose and objective preventing or punishing Ukraine for committing genocide. C. The Russian Federation shall refrain from any actions and shall provide assurances that no action is taken that may aggravate or extend the dispute that is subject of this application or render this dispute more difficult to resolve. D. The Russian Federation shall provide a report to the court on measures taken to implement the court's order on provisional measures 1 week after such order, and then on a regular basis to be fixed by the court. Madam President, members of the court, before I conclude Ukraine's case on its request for provisional measures, I would like to refer to the words of the Secretary General of United Nations, Antonio Guterres, immediately following the resolution of the General Assembly condemning Russian actions. And here I quote, "People of Ukraine desperately need peace, and people around the world demand it." End of quote. On behalf of the government of Ukraine and on behalf of the people of Ukraine, I thank you for your attention in this matter of national life or death. I respectfully urge the court to issue your order with utmost urgency. We are in your hands. Thank you.
I thank the co-agent of Ukraine, whose statement brings to an end the hearing on the request for the indication of provisional measures submitted by Ukraine in the case concerning allegations of genocide under the Convention on the Prevention and Punishment of the Crime of Genocide, Ukraine versus Russian Federation. I would like to thank the agent, co-agent, counsel, and advocates of Ukraine for their statements. In accordance with the usual practice, I shall request the agent of Ukraine to remain at the court's disposal to provide any additional information the court may require. The court will render its order on the request for the indication of provisional measures as soon as possible. The parties will be advised in due course as to the date on which the court will deliver its order in a public sitting. Since the court has no other business before it today, the sitting is declared closed.
exists in Ukraine, in particular in Donbass, it was really like the position of the Russian Federation leadership in order to start the invasion of Ukraine since 24th of February. And it was also the political statement of the Russian Federation in order to make the so-called recognition of some entities on the territory of Ukraine in Donetsk and Lugansk Oblast. So it's quite a normal legal way for us to show that really the position of Russian Federation is null and void, is absurd, and there is no genocide now committed by Ukrainian officials in the territory, both of Donbass and in general the whole territory of Ukraine. It's important because this is the principal judicial body of the United Nations. International Court of Justice is a court whose jurisprudence is of primarily importance for the world in whole and for many international organizations, international courts and tribunals. So that is why we are here with our team, and we did our best in order to prove and to show the court that the Russian allegations are absurd, false, null and void.
Скажіть, будь ласка, ви приводили як приклад кейси з моряками. Якщо вийде так, що в даному випадку це рішення суду не стане, скажімо так, прецедентом, приводом для Росії, його якимось чином виконати чи там дати, що вона виконує, які є взагалі механізми натиснути на неї, і яке це значення рішення тоді матиме взагалі в загальній площині?
Це рішення матиме ключове значення для продовження консолідації, підтримки наших партнерів і інших міжнародних організацій. Тому що всі держави світу, крім за невеликим виключенням, розуміють, що рішення Міжнародного суду ООН і рішення правосуддя треба виконувати. Для нас це може стати додатковим аргументом. Ми просимо, щоб це відбулося найближчими днями.
Ми просимо негайно, urgently.
Urgently. Все, пішли.
Okay. Thank you so much.
Може ви тоді скажете, які ви бачите перспективи стосовно розслідування Міжнародного кримінального суду? Слідство зараз...
Все правильно, ми вважаємо абсолютно, що це ще один трек, і тут в цьому суді, Міжнародному суді ООН, ми говоримо про відповідальність держави, тут розглядаються міждержавні спори. Міжнародний кримінальний суд, який теж базується тут у Газі, і ми знаємо, що багато хто досі плутає ці юридичні механізми в Україні, судові інстанції. Це є необхідний теж елемент, він розглядає питання індивідуальної кримінальної відповідальності за найтяжчі міжнародні злочини. А ми впевнені, ми бачимо, що Російська Федерація, її політичне керівництво, її військовий персонал вчиняють на території України, зокрема, злочини проти людяності та воєнні злочини. Тому Міжнародний кримінальний суд абсолютно як той механізм, який доповнює національні суди в контексті міжнародних злочинів, ми вітаємо їх рішення.
Ми не будемо забирати в наших колег їхні досягнення, і тому ці питання, будь ласка, ставте до Генеральної прокуратури України.
Дякуємо. Слава Україні!
Слава Україні!
Папочки наші заберуть?
Так. Would you take our folders?
Wait, thank you. Yeah, we carry it.
Так. Боже, а що це таке? Чекай, я просто не зовсім хтось тут там приклеїв. Чики. Так. Yours.
Like it's hot.
May
Yeah, no worries. Yeah. you see, it was impossible.
Yeah, I know. Since I didn't bring mine.
Okay. From
Jan?
Schnell draußen gehen. Draußen oder da? Das kann sein, dass das wird. Du hast Zeit. Der Licht ist nicht genug. Licht ist nicht genug. Du hast Zeit.